prior to 2000?
Because I don't think that's what the statute does. The 2000 legislation, respectfully, Your Honor, as I say, is subjected to at least two different interpretations. The Supreme Court and this Court both have concluded that taxing statutes have to be construed against the government and in favor of the taxpayer. That confusion in the 2000 legislation, in my judgment, would certainly even immunize the people who took the ceded reinsurance deduction prior to the effective date of the statute from ever having to pay those taxes. And to my knowledge, there's been no request.
Yeah, but if you receive a refund, but the agency seeks underpayments from those insurers, wouldn't they then be at a disadvantage?
If that were the fact, I suppose if there was in fact a refund that was granted, what we have here is a discriminatory taxing application. Some people were permitted to pay their tax on one basis, some people were permitted on another. And under that circumstance, I would say that it's certainly unfair to permit some to pay on one basis and others to pay on another.
Well, you're permitted to pay. I mean, realistically, that is based upon an argument that the agency was not aggressive enough, in your view, in collecting. I mean, that's like the Department of Revenue probably is aware that people make online purchases and don't pay sales tax or use tax, even though they're legally obligated, and some people probably do pay. So is that the same situation? So I suppose we should give a refund to everybody who's ever paid any use tax on an online purchase?
No, I don't think it's a question of whether or not they didn't enforce it rigorously. I think it's a question of statutory interpretation, plain and simple. The statute here doesn't admit of that kind of interpretation. Both the legislature in 624-510, which was passed in 1997 and defined the phrase net premium to exclude ceded reinsurance, and the Department, both consistently during the operative time period, interpreted this statute to exclude ceded reinsurance, and it should be, the judgment below should be affirmed.
Was that just the 10 minutes or was that the full 15 minutes?
Please, the Court, Your Honor.
Counsel, I'm sorry. Your co-counsel has used up your full 15 minutes.
Your Honor, I would ask that Mr. Volpe is not co-counsel, and we have issues that are specific to FHM for the appeal that have nothing to do with RISCORP.
Well, you know, we authorized 15 minutes to a side on this appeal,
Your Honor, if I may indulge the Court just for 2 minutes of the Court's time. There are some specific requests for admissions that have never been addressed by the State in the brief, Your Honor. And specifically, if you look at tab 3 to the brief of FHM's appendix, or the appendix to FHM's brief, it states, FHM is entitled to a refund or credit in the amount of $129,900 for overpaying its WCATF assessment, its Administrative Trust Fund assessment. This was admitted when they didn't respond. They have never moved to withdraw these. They have never sought relief from these. They've never even addressed them in their brief. Every single element of FHM's judgment that we're here on today was admitted when they failed to respond to these admission requests. And these are all included within our brief. They were mentioned in the brief, and they still have never addressed them in the reply brief. They've never addressed them before, again. Your Honor, these are separate than the request for admissions that they tried to withdraw on brokerage fees and commissions 2 years previously, that the Court correctly found that these and other admission requests are consistent with the record. They were not some type of technical error. There was no unintentional deviation here from what is correct or right. They just decided to come up with a new legal strategy a year in and say, we're going to take all these admissions off the table, and I'm sorry that we may have destroyed evidence. Mr. Huebner argued that, Your Honor, that the evidence destroyed was not for the operative time frame. In fact, 99 to 2000 was the evidence that got destroyed, and that was the testimony of Mr. Altavilla. During that time frame, they had an internal audit going on brokerage fees and commissions where the State and the Department said, we don't need any assistance from the Inspector General. We have a policy for at least the last 4 years of permitting these deductions for brokerage fees and commissions. Therefore, we are not going to respond to the audit. This is our existing policy. Where are all the records we have concerning this whole process? These were what was lost. They tried to withdraw more than entitlement. They also tried to withdraw that they had the historical policy and permitted people to take these deductions. Finally, Your Honor, there has been a lot of discussion regarding the Chapter 2000 law. We would say, Your Honor, that the legislature is not free to clarify a 1993 enactment when the controversy started immediately with the enactment. The State's own affidavits showed that, Your Honor. There was 7 years later they tried to clarify it. There was not a position of rogue attorneys or rogue employees. Everybody involved in the department was involved. According to Mr. Dion, did you have the authority of your client to take this position? Yes, I did. Did you, and we did a follow-up question on page 84 of his deposition, which said, were you acting on behalf of the department? Yes, I was. These are not unauthorized actions of the general counsel. This was the department taking a position, and permitting competitors of FHM to be favored. And we would ask that without even just looking at the admission requests alone that they did not respond to in May of 2002, and without moving for any type of relief from those admissions, there can be no error. Without a motion, without relief, FHM's judgment is proper. And the court, in its final summary judgment in favor of FHM, specifically referenced the request for admissions and the other admissions on the record in support of it.
Counsel, did you pass the cost of the assessments on to your policyholders?
No, Your Honor, we did not. The idea of a whole pass-through defense and this equitable defense that they're trying to raise now is barred. They have engaged in an admitted differential treatment and discriminatory taxing scheme. Under Florida law, the Dryden and Galesian cases, equitable concerns can be raised in the event they have had a prospectively good faith statute that they've relied on and applied evenly across the board. There's no question and there's no dispute that they did not apply this evenly across the board. They've offered evidence that only 10 or 15% or 20% of the carriers were taking it. In fact, they include in that analysis carriers that have no premium in the state, carriers that have under $100 in premium, because there are many carriers on their list who just aren't actively doing business.
Counsel, I'd like you to finish up now, please.
Yes, Your Honor. We would say, Your Honor, based upon the request for admissions, both the ones in May of 2002 and the ones back in May of 2000, that the FHM's entire judgment is supported. Certainly the component of brokerage fees and commissions that make up about 40% of our judgment is fully supported by the court's order refusing to permit the withdrawal. Without even moving to withdraw the other admissions, they can't have relief, and there's no error below.
Mr. Huebner, we're going to add 2 minutes to your rebuttal time.
Let me begin by saying that we obviously have some differences about what's in the record, and I stand on what I have said to the court. The point I wish to make is that if these differences are supported by the record, the summary judgment cannot stand, because the court did not base its final judgments, its summary judgments, on any attempt to resolve all these disputed facts. Basically, the rationale of the court, to the extent you can understand it, was really that Chapter 00-150 changed the law, and the department's interpretation for all those years was wrong. Therefore, we lost. She did not attempt to get into this, couldn't have done so on the summary judgment, and resolved about issues about whether the deductions that were taken were done so with the department's approval or not. I don't believe that most of them were. I believe that some of them were done with the department's knowledge, or at least the knowledge of the lower level employees like Mr. Weatherspoon. Mr. Bergelia has said that this case can be decided on what the statute means. I would like to point out to the court that neither of the statutes ever say that the cost of reinsurance can be deducted to reach the net. What they're asking for is, in effect, an exemption or an exclusion that they get to deduct the ceded premiums from some kind of gross figure. A statute like that, where they are asking for special favors or exemptions, has to be construed against them. I could give you 10 reasons why the department was correct in its construction of the statute, because of the impact that their interpretation would have. It would mean that far less money was collected for these funds. I think one might infer that the assessment rates that the legislature set over the years were probably done so